Welcome to What's New in Municipal Law 2020, Part 2, Recent Court and Appellate Tax Board Decisions. We will now review the decisions in Part 2C relating to municipal finance and land use. We'll start with cases dealing with finance issues. Boss v. Town of Lafayette. This case deals with retiree health insurance and town meeting warrants. Boss, a retired public school teacher, filed suit claiming that the town of Lafayette is obligated to pay 50% of cost of health insurance premiums for retired town employees and dependent spouses. There were two issues in this case. First, does General Law, Chapter 32B, Section 9A, obligate the town to pay 50% of retiree and dependent costs? And the second issue was if Section 9A is interpreted to include dependent premiums. Was Section 9A effectively adopted by the Lafayette Town Meeting in 2004? The court discussed that General Law, Chapter 32B, Section 9A, provides that a town may provide that it will pay 1/2 of the amount of the premium to be paid by a retired employee under the first sentence of Section 9. So, the focus of Section 9A, the court reasoned, is on the retiree payment. And here, Boss's payment was based on a group plan that included her husband. This plan that included her husband was in effect when she was an employee, well before her retirement. As a result, the court concluded that Section 9A requires the town to cover 50% of the premium that Boss pays, not 50% of what it costs to cover her individually. That means the 50% must cover Boss's costs for herself and her dependents. The next question for the court was whether the Lafayette Town Meeting had properly adopted Section 9A, which contained the 50% premium requirement. The town argued that the town meeting warrant was defective and misleading, and the votes to adopt Section 9A were invalid. The court said that the general rule on town meeting warrants is that the subjects to be acted on at a town meeting must be sufficiently stated in the warrant to apprise voters of the nature of the matters with which the meeting is authorized to deal. A town meeting vote is invalid if the language in the warrant is misleading, if the language included or excluded in the warrant substantially alters the article's meaning, or if the warrant fails to sufficiently state the nature of the matter. The court concluded that none of these circumstances existed in this case. No evidence was presented showing the voters were confused by their vote, and no authority was cited that if they were confused, then a court is empowered to order a new vote. The warrant met the standard of giving notice of the nature of the business to be acted on, and, as such, the vote was valid. And once Section 9A was adopted by the town, Section 32B prohibits its rescission or revocation. In closing, the SJC upheld the decision of the Superior Court declaring that the town must pay 50% of the full premium cost for health insurance for Boss and other retired town employees and their dependents. Now we're going to look at 4 court decisions dealing with land use and property rights in the municipal context. The first case is Gentilly v. Sturbridge. This is an adverse possession prescriptive easement case. In this case, in an earlier suit, the landowners Fulvio Gentilly and Gina Madore, trustees of the Renato Gentilly Trust, sued the town of Sturbridge over the town's discharge of water over their property. At that trial, the judge concluded that the town had acquired a prescriptive easement through 20 years of adverse possession by its continued uninterrupted discharge of stormwater onto the trust's property without the trust asserting any rights to stop it during that period of time. The trust did not appeal that judgment. Instead, the trust filed a new action seeking damages under Section 10 of the Eminent Domain Statute, Chapter 79 of the General Laws. The trust argued that the easement was a taking for which town must pay just compensation. The court held it is too late for a damage claim. The town's prescriptive easement, acquired after the 20 years of its adverse possession, now allows the town to discharge the stormwater without paying compensation. It has an easement. The trust should have stopped the town before it used the property for the 20 years required to obtain property rights through adverse possession. Marchese v. Boston Redevelopment Authority. This case involved eminent domain. In 2003, in order to facilitate improvements to the area around Fenway Park, the Boston Redevelopment Authority exercised its eminent domain powers as an urban renewal agency and acquired a 10-year limited easement over a portion of Yawkey Way and licensed its exclusive use to the Red Sox for home games. At the expiration of the 10 years, the BRA did a permanent taking of an easement and sold the easement rights to the Red Sox for as long as Major League Baseball games are played at Fenway Park. Marchese claimed that the BRA exceeded its authority in relation to the permanent taking in 2013 because the area was no longer blighted. He also argued the Yawkey Way easement rights should have gone out to bid. giving him an opportunity to buy the easement. The court ruled that Marchese, as a private party with neither a property interest nor an existing business that would have been adversely affected by the taking, lacked standing to challenge the BRA's actions. In essence, Marchese was owed no duty and suffered no injury. Concerning the right to bid on the Yawkey Way easement, the court noted that if the taking by BRA was proper, then the subsequent sale of the easement was exempt from bidding law requirements. If the taking by BRA was not proper, the easement would revert to the City of Boston, which would have no legal obligation to put the easement out to bid. In either case, there was no obligation to subject the easement to public bidding. Maroney v. Planning Board of Haverhill. Michael Maroney was the developer of a 50-lot residential subdivision in the city of Haverhill. The Haverhill City Council gave him a special permit, and the city's planning board approved his definitive subdivision plan with the requirement that he install a water pressure booster station to address low water pressure problems. Maroney started construction immediately without building the water pressure booster station, since many of the lots were considered serviceable. When he attempted to develop additional lots, however, the water department refused to sign off on the site plan due to insufficient water pressure. The city insisted that Maroney had to build the water pressure booster station before starting construction on the remaining lots. Maroney then filed suit in Superior Court to compel the city to issue the necessary permits. He also began construction on some lots without permits. The Haverhill building inspector issued a cease and desist order, and in Superior Court counterclaimed for civil penalties for the unauthorized construction activity. The Superior Court ruled in favor of the city by rejecting Maroney's claim for the permits and awarding over $970,000 to the city in civil penalties for the illegal construction. On appeal, the appeals court noted that Maroney was no longer the owner of the subject property which he lost through foreclosure. Accordingly, the appeals court ruled he had no legal interest in obtaining the permits, and his claim for the building permits was dismissed as moot. As for the civil penalties, the Haverhill building inspector had imposed fines of $1,300 per day for unauthorized construction when Maroney ignored his cease and desist orders. The $1,300 figure for each lot consisted of $300 per day for violation of the local bylaw and $1,000 per day for violation of the state building code. Haverhill had raised its claim for the fines and a counterclaim to Maroney's request for the permits. The appeals court, relying on prior court decisions, held that a counterclaim is not the proper route to impose civil penalties under a local zoning bylaw. According to the court, Haverhill should have followed the procedures in Chapter 40, Section 21D of the General Laws to pursue local fines. Under Section 21D, the city would be required to provide written notice to the violator to appear before the district court clerk no later than 21 days after the date of the notice or pay the fine. The city also failed to comply with the statutory proceedings for imposing fines for state building code violations. It should have followed Chapter 148A, Section 2, which requires notice to the offending party and a hearing if requested. By failing to follow statutory procedure, Maroney was denied notice and an opportunity to be heard. For these reasons, the appeals court struck down the lower court's judgment awarding the civil penalties to the city. Bryce Estates Incorporated versus Town of Rutland. A developer challenged in land court a Town of Rutland bylaw, which restricted town-wide residential building permits. The developer claimed the Rutland Development Rate Limitation bylaw was not constitutional and was contrary to the state zoning laws. Rutland Town Meeting, by a 2/3 vote on May 11, 2019, approved the bylaw which provided for no more than 36 permits for dwelling units in a calendar year. The bylaw also provided that no more than 25% of the building permits be issued to any one applicant within a calendar year. The bylaw also exempted certain parcels from its provisions, A&R lots. An A&R lot is one that results from the division of land into lots with frontage on existing roads. The developer argued the potential 10-year duration bylaw was not constitutional under the Due Process Clause and violated the Massachusetts zoning law, Chapter 40A of the General Laws. Bryce contended the bylaw could not be characterized as temporary and cited Supreme Judicial Court cases which held that bylaws restraining growth for an indefinite duration are unconstitutional. However, the land court found that the Rutland bylaw was temporary due to its sunset date and the potential 5-year one-time extension, which had to be approved by 2/3 vote of town meeting. Having dispensed with the constitutional argument, the land court turned to Bryce's statutory claim. Bryce had alleged that limiting an applicant to no more than 25% of the building permits and exempting A&R lots from the bylaw violated the uniformity requirement of Chapter 40A, Section 4, which is based on the principle that land in similar circumstances should be treated in the same manner, so that if anyone can proceed with a certain development, then so can everyone else. The Land Court ruled that the Rutland bylaw was valid under the Home Rule Amendment of the state constitution, except for the provision that exempted A&R lots and limited the number of permits that could be issued to any particular individual in a calendar year. And that concludes Part 2C's Cases and Decisions. Please join us for Part 2D, the final segment of What's New in Municipal Law, where we look at other municipal decisions.